So good morning, everybody, and welcome again to our second session of the day that will focus on family relations and internal tensions. We have three speakers. Unlike the previous session, we will all the lecture and then questions and answer will follow immediately after the lecture. So I do ask the presenters to stay here on stage and take the questions. Our first speaker of the day is Dr. Ouriel Simonson from the Department of Middle Eastern History at the University of חיפה. And you will talk about Jewish Apostates and their relatives in Geonic Responsa. Well, Dr. Simonson, please.
Almost good afternoon to everyone. Still good morning. I have to apologize. I won't be able to stay for the whole session because I have some teaching obligations awaiting me at חיפה. So I apologize for that. The fact that at least some of the converts to Islam in the early Islamic period, as perhaps also converts to other religions in other periods and regions, did not detach themselves from their family members who had not converted, will be the underlying premise of my brief talk. A rich and diverse collection of literary testimonies of Islamic, Christian, Jewish, and even Zoroastrian provenances from the early Islamic period strongly suggest that shifts in religious affiliations did not necessarily entail social ones. Rather than making a point about the endurance of family ties in the context of conversion to Islam in the first few centuries following its takeover, my present concern will be with the different types of such ties as they can be seen through the legal correspondences between Rabbinite Jews across the Mediterranean between the 9th and the 11th centuries. These correspondences are best known as Geonic Responsa, the answers of the supreme legal authorities of the rabbinic world during the classical Islamic period, the Geonim of Babylonia. Formulated in the Geonic academies of Baghdad, these responsa were issued in reply to legal questions sent in from various parts of the medieval Jewish world. The majority of the surviving responsa are the ones that were given to Jewish communities in North Africa and the Iberian Peninsula. They cover a wide range of legal topics, including questions of ritual, civil law, and communal administration, and as such, provide an intriguing glimpse into the lives of contemporary Jews and Jewish communal affairs. Typically, the Geonim try to adhere as closely as possible to early rabbinic sources when formulating their opinions, as heirs to a chain of rabbinite authorities beginning with the Palestinian sages of the Mishnah and continuing with those of the Babylonian Talmud. The Geonim relied in their opinions on the principles that had been laid down by their predecessors. An examination of those responsa, which deal with the legal problems that emerged in context of individual conversions of Jews to Islam, brings to the fore a few immediate insights. First, the legal treatment of apostasy by rabbinite authorities in the Geonic period is unprecedented, particularly when contrasted with the classical rabbinic period. Second, among the conversion-related cases that were brought to the discretion of the Geonim, the category of family and kinship concerns is by far the largest. And third, modern historians are bound to gain further insights by delving into both the question and answer parts of the responsa. While the questions tend to highlight a variety of social scenarios, the answers speak of instances in which the Geonim were lacking consensus or even prone to innovate. Thus, in what follows, I will provide few examples of Geonic responsa that both portray different forms of apostate Jewish family ties and suggest an intriguing tension between two poles of Geonic approaches, namely, one which sought to alienate apostates at whatever cost, and another which considered apostates as legally bound to Judaism irrespective of their shameful choice to leave it. A recurring question in Geonic Responsa dealing with the place of apostates vis-à-vis their family ties comes up in relation to Yibum and Chalitza, namely the duty of a man to either fulfill or his deceased and childless brother's duty to procreate by marrying his widow through levirate marriage, or release her, thus allowing her to remarry. The particular problems that arose in this context had to do with circumstances in which either the deceased or the levering brother had apostatized, thus questioning the liability of the lever to fulfill his duty. A responsum attributed to an anonymous Gaon suggested the Geonim differed on this matter. While some argued that the widow remains bound to the apostate lever until he releases her, others, quote, innovated in this matter, saying that if, at the time that her husband married her, his brother was already an apostate, she does not require chalitza from him, unquote. Moreover, according to these Geonim, quote, if the husband was an apostate and she, that is his wife, dwelt in his domain and he died being an apostate, having no children, she does not require neither ibum nor chalitza, since his Jewish brother is not considered his brother, end of quote. The idea at the basis of these innovative positions is that a levirate marriage or release is no longer deemed necessary when either the deceased or his brother had apostatized, since the act of religious conversion invalidates the legality of their kinship. They are no longer considered brothers. The proponents of this latter position were met with the blunt objection of certain Geonim, such as the 9th century head of the Pumbedita Rabbinic Academy, Paltoi Gaon. The question posed to Paltoi mentions two brothers, one of whom apostatized and moved far off from his family, whereupon his Jewish brother died, leaving behind a childless widow. According to Paltoi, the widow, quote, is chained and remains such forever. There is no solution for her, and she cannot marry until the apostate performs a chalitza for her, since the apostate lever's conception and birth was in sanctity, that is, he was born as a Jew. She requires a levirate marriage, and that chained woman is not released until he performs a chalitza for her, end of quote. Here, an interesting contrast should be noted. In the former case, where the Geonim ruled in favor of releasing widows of deceased apostates or of deceased women or of deceased Jewish men whose brothers apostatized, the apostates appear to have been in relative proximity to their Jewish families, thus being able to perform their legal duties, whether as husbands or levers. At the same time, in the latter case, where the apostate lever had clearly distanced himself from his kinsfolk, he was considered legally bound to them. The tension between the legal and the kinship ties of apostates with their former co-religionist family members is illustrated in matters pertaining to the legal standing of apostate women. These make their appearance in responsa that address the status of the property brides had brought along upon their betrothal, namely their dowries. In a responsum attributed to either Rav Shrira or his son Rav Hai, both heads of the Pumbedita school towards the close of the 10th, early 11th century, we learn about a certain woman who apostatized while married to a Jewish man. The woman had entered matrimony bringing a rather handsome dowry comprising of fields, houses, and vineyards. We may assume that consequent to her death, a debate arose as to whether the property that she had brought in was to be claimed by her father's household or by her husband. The latter argued that her apostasy rendered the woman legally dead, hence he is the rightful heir of his wife's property. The Gaon's reply, however, not only negates the husband's line of argument, but also suggests that the apostate's ties with her family remained intact. According to the Gaon, quote, that apostate is considered an adulteress, zonah, and the sages said, even if the wife committed adultery, did her worn-out articles commit adultery? Therefore, her heirs take her articles, end of quote. In another responsum, however, we see that the apostate woman was viewed to be completely removed from her familial ties. The responsum attributed to the first half of the 9th century head of school of Surah, Rav Amram Gaon, mentions the case of a deceased apostate woman for whose property her father made a claim. The Gaon ruled that the father has no claim over her property whatsoever since, quote, she has left the laws of Israel and entered the laws of non-Jews. Hence, whoever lays his hands first on the property acquires them, end of quote. Indeed, matters of inheritance occupy a significant portion of Geonic Responsa that deal with family ties between Jews and apostates. Among these, we find a blunt expression to the alienation of apostate Jews from the Jewish fold, as can be seen in a series of responsa attributed to the 9th century head of Surah, Rav Natronai bar Hilai Gaon. Natronai disinherited the Jewish apostate from the legacy of his father on the grounds that he, quote, has gone out of the sanctity of Israel and the sanctity of his parents, and an inheritance is only for an Israelite who traces his lineage to his father, end of quote. Natronai did not base his opinion on an earlier rabbinic principle, but rather expanded on the discussion in Bavli Kiddushin, which deals with a Jewish proselyte's right to inherit from his Gentile father, and on Genesis 17:8, where it is written, quote, and I will give to you and to your offspring after you, etc., end of quote. According to Natronai, the divine promise was given to Abraham with regard to his offspring who traces his lineage after him, thus excluding an apostate. The latter, according to Natronai, quote, causes the transfer of an estate from one nation to another, and we do not permit this, end of quote. Natronai's approach has been convincingly described by Oded Irshai as an important milestone in Geonic positions and was adopted by later Geonim from Surah, but rejected by Geonim of Pumbedita. Thus, according to an anonymous Gaon, an Israelite who apostatizes inherits his Israelite relatives. However, quote, if the court of law sees fit that the apostate should lose his fortune and fine him so that he may not inherit, in order not to strengthen the hands of the wicked, it has permission to do so. In case there are Israelite sons, their apostate's father's inheritance will be given to them, and thus is the custom of the Geonim of the West, end of quote. Through this latter opinion, we learn that the disinheriting of apostate sons or the Jewish heirs of apostate fathers was not a default course of action, but in certain instances where the rabbinic court decided to expropriate the apostate's inheritance in order to discourage apostasy. Addressing the case of an inheritance of a Jew whose apostate father, of a Jew from his apostate father, the early 11th century head of Pumbedita, Rav Hai Gaon, argued that an inheritance can be passed from an apostate to a Jew. Hai Gaon was in the opinion that since a non-Jew inherits his non-Jewish father, an apostate inherits an apostate, and a proselyte inherits his non-Jewish father, then, quote, an Israelite inherits an apostate, end of quote. The disinheriting of apostate descendants or Jewish descendants of apostate fathers is a well-known principle in Islamic, Zoroastrian, and Christian legal traditions. Natronai's position cannot be read in isolation from its contemporary non-Jewish legal contexts. Yet the facts of the matter remain. First, from a legal perspective, we should note the attempt to expel apostates from the Jewish fold by creating a tangible barrier across familial lines, an attempt which was not uniformly endorsed within the Geonic milieu. Second, whether disinherited or not, the question highlights a social reality in which apostates remained close enough or maintain some form of contact with their former co-religionist kinsfolk, so to be able to demand a share in their father's legacy. The final aspect of apostasy in the context of family ties that I wish to address concerns questions that arose with regard to children who were born to apostate fathers. In a question referred to Rav Shrira Gaon, we hear about a Jew who apostatized while married to a Jewish woman. The couple had a child who was born on a Sabbath, which meant that the boy would have to be circumcised on the following Sabbath. The Gaon was asked whether the circumcision could indeed take place on a Sabbath. Clearly, the question at hand was not whether circumcision, a ceremony which entails bloodletting, is permissible on a Sabbath, or circumcision precedes the law of the Sabbath. Rather, questions regarding the postponement of circumcision would normally arise when there was a threat to the infant's well-being. However, in the absence of an explicit reference to the cause of concern in the background of the question, it may be inferred that the concern was a possible contention over the religious identity of the infant. Chai Gaon replied that the child ought to be circumcised on the Sabbath, arguing that the child is an offspring of Abraham and, quote, the generations of apostates do not become entrenched, but it was just one person who apostatized, and perhaps he will rethink it and leave his son in the Jewish religion. Furthermore, Chai suggests, for the child's mother is an Israelite, and perhaps the child will follow her, and we do not presume that he will go astray. Therefore, we do not have the power to forbid his circumcision on a Sabbath, end of quote. On the face of it, the case suggests a family household which remained intact despite the conversion of the father. Yet despite the underlying principle of the child's Jewishness being determined by that of his mother, both the petitioner and the Gaon appear to be aware of the threat to the child's Jewish affiliation that could have been caused by the presence of his apostate father. In another responsum, mentioning the upbringing of a child whose father left the Jewish fold, we come to appreciate the overlapping of legal and normative concerns. The responsum referred to the renowned 10th century Gaon of Sura, Rav Saadia Gaon, speaks of a Jewish woman whose Jewish husband went overseas, and in his absence she married a Jewish apostate, quote, according to the custom of the Gentiles, unquote, namely before a non-Jewish court. The Jewish woman gave birth to a boy, and later her Jewish husband returned and gave her a divorce. The problem at stake was whether the child was considered halachically fit, since his father is considered a Gentile, as the principle is that a Gentile who has sex with a married woman, their child is not considered a bastard. Yet Saadia Gaon did not consider the apostate as a Gentile in this particular case, ruling that with respect to religious duties such as, quote, betrothal, divorce, untying a widow, refusal, that is, a minor girl's refusal to consummate a fixed marriage, and bastardship, end of quote, the apostate is considered a Jew in every respect. Therefore, Saadia ruled, the boy is indeed a bastard. Seen together with the preceding responsum, in which the concern over the child's Jewish identity was considered through a normative dimension, namely the child's future upbringing by an apostate father, Saadia's position reflects a legal dimension in which the father is considered a Jew despite his apostasy. To conclude, just like other religious communities, the Jews living in the Abd of Islam in the early Islamic period faced a variety of questions that came up in the context of the conversion of their co-religionist to Islam. In the context of families, nucleus or extended ones, the choice of Jews to convert triggered a series of legal questions, such as the validity of marriage contracts, the applicability of levirate arrangements, the execution of wills, and the place of children. These questions were addressed to the heads of the rabbinic academies in Baghdad from as early as the second half of the 7th century to as late as the 11th. Beyond their legal significance, Geonic Responsa allow us a narrow glimpse into a historical period which is otherwise very poorly documented from the standpoint of social historians. They offer us some of the moral, legal, and social dilemmas with which the Rabbinite Jews grappled in this period as their kinsfolk chose to renounce their Jewish faith. Concurrently, these deliberations permit the assumption that the conversion to Islam of certain individuals did not necessarily entail their complete detachment from their families. It seems apparent that the concerns that show up in Geonic Responsa were consequent to a reality in which the converts remain in proximity to their former social environments. Thank you.
Thank you very much. We will take questions. We have some 10 minutes for that, so the floor is open for discussion. Please.
I didn't make my point clear enough. My point was that it is family-related matters in the context of conversion. That I don't know a third. I don't know if it's a fourth or a fifth. I'm just saying that there is this portion in Geonic Responsa that deal with apostasy, conversion, and within that portion, the largest part deals with family-related matters. That's what I'm saying. Now, as regards to unprecedented in the precedence of classical rabbinic materials, it is a striking difference. It most likely has to do with the distinct genres. Nonetheless, I am detecting a difference, an historical difference. I think I mentioned this to you. It's another opportunity, but I'll say it again. In principle, a Jew can never leave the Jewish fold. Okay, he can embrace Christianity, Islam, whatever, but he was born Jewish, and therefore he's a Jew forever. And it's a given. And the classical rabbinic material treat apostates and others who cross the lines as such. Let's forget for a moment from the Geonic period and move straight into Ashkenaz. In Ashkenaz, this is very similar, almost exact idea. It comes up, and of course, the most famous opinion is that of Rashi. Israel, af al pi shechata Israel. What I am detecting, though, in the Geonic Responsa that do serve as a precedent to Ashkenazi opinion, is a moment in which some of the Geonim, not all of them, perhaps not even the majority of them, are thinking along the lines of other monotheistic confessions, that the embracement of a new religion entails a social detachment or a communal detachment. And this is what we can see through some of these responsa, that disinherit apostates, that release levers or widows from the duty of Ibum and Chalitza, stating that these people are no longer part of the fold. So I am detecting here a momentary, if you like, exit from the classical rabbinic premise that is later continued by Ashkenazi authorities, but momentarily is excluded by some of the Geonic authorities. And my hypothesis at this stage is that they're very well immersed in a religious environment of Christian, Muslim, and perhaps even Zoroastrian traditions that operate according to the same principles.
Okay, if there's additional questions, if somebody would like to ask in Hebrew, that's also permitted, as I was informed. Let's see your place.
אתה יושב ראש. אוריאל, קודם כל מאוד מעניין גם ההסבר שלך לשינוי מסוים בתפיסה של הגאונים שאתה הזכרת, שהיא שונה מהתפיסה הקלאסית של יהודי הוא יהודי אפילו שחטא, כפי שאמר אחר כך רש"י. אני רוצה לציין שאנחנו לא מוצאים את זה, אני לא מכירה את זה במקומות אחרים, ובוודאי לא בתימן שאני חקרתי אותה, שם יהודי שהתאסלם הוא יהודי לכל דבר, וכאשר יש צורך לייבם, הוא חייב לייבם ואשתו תישאר עגונה עד שהוא לא יסכים לתת לחליצה. זאת אומרת, הקשרים הם קשרים שנשארים, אותו דבר, הזכרת 3 נושאים, הנושאים של חיי נישואים, של ירושה ושל ילדים. למשל חזקה על ילדים. יש את החזקה על ילדים אחרי שאחד מהצדדים נפרד מהקהילה. יש כאן בעיות שחוזרות ונשמות, אבל כאן אנחנו רואים ללא פשרה במסורת ההלכתית בתימן, יהודי הוא יהודי וכל הבעיות שנובעות מכך ומשפיעות על חיי המשפחה והאינדיבידואלי והקהילה כולה הם כתוצאה מהפסיקה הזאת. אז זאת הייתה רק הערה.
נישואים חוץ קבוצתיים והיהדות. עכשיו, רציתי לשאול, אני בטוחה שיש, אבל אני לא יודעת איפה, האם יש איסור הלכתי מפורש על זה, או שזה רק באמת איזשהו ניסיון של היהדות לשמור על עצמה, בצורה שאנשים לא יצאו החוצה ולא יכנסו פנימה, למרות שהיו תהליכי גיור מאוד מפותחים.
האיסור על נישואי תערובת הוא מאוד מוקדם, הוא מקראי. אבל זה לא המקרה פה. אנחנו מדברים על אנשים שהם יהודים.
לא, אני לא שאלתי ספציפית.
האיסור על נישואי תערובת הוא מבוטא בצורה הכי בולטת וברורה מתקופת עזרא ונחמיה. והוא עובר כל מיני גלגולים בהקשר לגרים, כאשר בתקופות מסוימות גרים כן מתחתנים בישראל, ובתקופות אחרות הם לא, ובתקופות מסוימות הם מותרים לכל מי שהוא לא מהכהונה. זה נושא שנדון בהרחבה. מה שמעניין הוא שהאיסור על לשאת גרים בתקופת עזרא למשל הוא על בסיס עקרון של יוחסין של דם, הייתי כמעט אומר, בעוד שבתקופה של חז"ל ואפילו לפני כן תקופת החשמונאים הוא עובר לאיסור שהוא על בסיס אסור להינשא לאנשים שהם קטגורית מבחינה מוסרית, אבל לא מוסרית של מוסר, אלא שהם לא מחזיקים באמונה באל של ישראל. כלומר, המעבר הוא מעניין ביולוגי לעניין ערכי. וברגע שהמעבר הוא מעניין ביולוגי לעניין ערכי, זה פותח את הדלת בפני גרים רבים להינשא בישראל. עכשיו, הרלוונטיות, אני בכל זאת מושך לדיון בנושא מומרים, זה שברגע שהעיקרון המוסרי צף מעל פני השטח, שהוא הופך להיות במרכז, זה בהחלט מעלה שאלות לגבי הנוכחות של מומרים במרחב היהודי, מכיוון שאומנם הם ביולוגית יהודים, אבל מוסרית הם לא.
question if there is a definite, go ahead.
אני לא בטוחה שזה שורט, אבל השאלה שורט, לא בטוחה לגבי התשובה. אני ממזגת, בכל אופן, קודם כל תודה רבה, זאת הרצאה מרתקת. אני דווקא, אחד הדברים שמשכו את תשומת ליבי, זה היה הניסיון של אותם גאונים, בשלהי התקופה של הגאונים כמובן, גם להתייחס לדור הבא, לדור של הבנים, ולהשאיר אותם שם. זאת אומרת, פה אתה רואה איזושהי פתיחות, איזושהי אינטרפרטציה שונה, כדי לדלג על הדור הקודם של המומרים ולהגיע ולהשאיר אותם לדור הבא ולהשאיר בקהילה. עכשיו, כפי שכולנו יודעים, זה באמת שלהי שירת הברבור של תקופת הגאונים, הגאון, של הגאון, הגאון לא. והשאלה היא, אני בטוחה שיש משהו ממש בקצרה שאתה יכול לומר, מה קורה כשהסמכות הזאת של הגאונים בעניינים שונים, כולל בעניינים שקשורים למומרים, היא למעשה עוברת תהליך של איזשהו פיזור ואפילו דעיכה. ויש מרכזים שונים, כמו מה מלמדים אותנו מסמכי הגניזה בנושא הזה של היחס למאה ה-11, 12 כמובן, מה אנחנו לומדים שם? האם יש משהו במעבר הזה, או בתמורה הפנימית, בשינוי הפנימי, בדינמיקה הפנימית הזאת, של הירידה של הסמכות של הגאונים של בבל, והמעבר למרכזים אחרים, האם אנחנו רואים גם איזשהם עדים לשינוי הפנימי הזה ביחס למאמרים?
Very briefly, if not, somebody.
אין לי דרך לתאר את השינויים באופן כל כך חד וברור בתקופה שלאחר הגאונים באמצעות מסמכי הגניזה. מסמכי הגניזה גם כן ממעטים לדבר על מומרים באופן יחסי לכמות מסמכי הגניזה שיש בידינו מאות אלפים ויש רק עשרות תעודות שעוסקות במומרים. ברוב המקרים אנחנו רואים ניתוק בין המומרים בזוגיות וכן הלאה. יחד עם זאת, יש לנו גם דוגמאות מהגניזה שמאשררות את העמדות שעולות בתשובות הגאונים. אני חושב שההתבוננות שלנו צריכה להיות פחות בגניזה כדי להבחן שינויים בעמדות הגאונים, אלא יותר במסורת של הראשונים ושל אשכנז, ואם היו בידינו מסמכים מהתלמידים החכמים שיושבים לאורך חופי אגן הים התיכון, זה גם היה עוזר קצת.